Well, hello, boys and girls. Greetings from the Arctic of Vermilion. I'm afraid our palm trees and sandy beach are covered with snow today, but nevertheless, we are going to drive on with our favorite subject today, which is security interests. Now, this is a continuation from last week. We split chapter 24 up, and you can see chapter 24 in your online link for week 5. The content you can click on and it'll bring up the text material. But of course, we have to ask the commercial question. Well, why should we be interested in perfection and purchase money security interests? Boy, sounds complex. Well, when businesses sell goods, so let's take an automobile dealer who sells a car, or a store that sells refrigerators or stoves or, expensive items. Clearly, the store is selling expensive items to a stranger. And while everybody is supposed to be acting in good faith, clearly, the seller has a lot of money tied up in this item that it is selling to the buyer on time. And so the law permits the seller to retain what's called a purchase money security interest, if you will, converting the sold item into collateral. So we'll talk about default in just a moment, but you can see financially why a business, when it sells an expensive item, wants to retain some legal interest, what we simply call a PMSI, in the item so that in the event of default, the seller can regain their property. Now, let's talk about perfection. When we have the sale of a consumer good, perfection automatically attaches without having to file a financing statement in the recorder's office of the county where the buyer lives. This is just a UCC provision under Article 9 that provides that the seller retains a security interest in the item being sold without the necessity of having to file it. Now, being the mobile society that we are, of course, the question naturally arises, well, what about, perfecting movable collateral and fixtures? Because clearly people change jobs and they move from, state to state. Well, what happens to the security interest when a debtor moves to another state? Well, the security interest remains in effect for a maximum period of 4 months. So if a creditor wishes to retain a security interest longer than 4 months, then he's going to have to go through the perfection process of recording it in the new county recorder's office of the county where the debtor has moved to. What about the collateral that's actually being moved to a new state? So we just mentioned that the security interest only remains in effect for 4 months. Well, the collateral, if it's moved to another state, like a washing machine or a TV, then the security interest remains perfected for 1 year only in that item when it's moved. So see a difference between a security interest when the debtor moves to another state and a difference when the collateral is moved to a different state. So let's take probably the common situation of when a debtor moves to another state. He brings his collateral, if you will, the purchased items with him, in which case the security interest will remain perfected up to 1 year. Got it? Now, if so let's take something like an automobile, and you've got a multi-year, so let's say you've got a 5-year loan on this automobile, then clearly after a year, the perfection would expire, and so it's in the secured party's interest to re-perfect the security interest in the new state. Again, by going through the process of filing the financing statement in the county recorder's office of the county where the debtor resides. When we talk about really big items like boats and autos and trailers, well, the filing may be ineffective. So normally you will find that security interests are printed on the title document. So let's take a car, for example. When a seller retains a security interest in the automobile, routinely on the title that is issued, there will be a statement in there that the automobile is subject to a lien by this named creditor in the amount of X amount of dollars. Now, it's important that this be done because clearly a seller doesn't want to lose their property by having buyers move from one state to another, and so they get this printed on the title. And of course, the only way the seller, when he sells the car and endorses the title over to a new party, they have to get the lien on the title, what is simply referred to sometimes as a clouded title. They have to get that removed, and the only way you're going to get it removed is obviously by paying off the debtor. Now, why go through all this process other than trying to protect the collateral of the seller? Well, bear in mind that the sellers often assign, that is, sell this instrument, this debt instrument, this security interest, often sell this to another entity for money. So they clearly discount it and then sell it in order to get cash today, as opposed to waiting 5 years to receive all the payments. So you can see the value of this process. And clearly, when dealing with strangers, as most sellers do in terms of automobiles and big ticket items, there is certainly a business incentive for the seller to perfect their security interest. Now, the benefit, of course, of perfecting a security interest is that it remains in existence when the collateral is sold or exchanged or transferred to another party. Now, the one exception to the rule, like the English language, there's lots of exceptions to every rule. Well, the exception is what's called a buyer in the ordinary course of business, a BIOC. If you have a buyer who purchases collateral from a debtor, and the debtor doesn't tell him or her that the item has a security interest by a seller or another creditor, the buyer will be buying that property without knowledge of the existence of a security interest. And as an exception to the rule, the security interest will expire because the new buyer has no knowledge of its existence. So, it's not uncommon for businesses that deal in expensive item goods, who want to certainly perfect them. Does that mean the original debtor is off the hook? No, because the security interest still exists with respect to the debt, right? So, What is required under the UCC with respect to all contractual transactions? Good faith, right? Good faith is not optional. Good faith is required by both the common law of contracts and the uniform code, the uniform commercial code. But looking back at a BIOC who takes a debtor's property, seller's collateral, if you will, without knowledge, takes such goods free of the security interest because they don't know the property has a security interest, unless it's something like that has a title that has marked right on it that clearly says that is subject to a lien by the seller in the amount of blah, blah, blah. Hey, a BIOC is going to see that when they get the title, and they know that the only way that's going to get off the title is by seeing that the creditor is paid off. This case is a good illustration of what we're talking about. So we've got a motor home. My wife made me buy her an Airstream trailer. They call them motor homes. Well, we call them glamping, glamorous camping. Well, these things can get pretty pricey. And so we've got the Williams family who purchases one of these rolling beasts from New World RV for $14,000 down, but financed $63,000, getting a security interest to New World in the RV. Now, the RV promptly sold, if you will, assigned its security interest to Conseco Finance, which perfected the interest. Now, this is really common in business. Rather than wait, for the debtor to pay off the loan over a period of time, the seller will simply turn around and sell it to another creditor like Conseco Finance. So we've got 2 years later, the Williams family returns the RV to New World, who resold it to Robert and Ann Lee for $42,800. Now, a year later, Williams defaulted because Williams is still liable on the original $63,000 debt, right? A year later, Williams defaulted on the payments to the finance company. So the Lees sued Conseco, claiming to be buyers in the ordinary course of business that had no knowledge of the previous security interest. Now, Conseco counterclaimed, seeking title based on its perfected security interest, which it had filed. Now, the trial court ruled in favor of the Lees, finding that under the Uniform Commercial Code, they were in fact buyers in the ordinary course of business who had no knowledge when they purchased the RV of the security interest. Because the rule of law is simply a buyer in the ordinary course of business takes goods free of any security interest. Now, certainly the Williams are still on the hook to Conseco, but foreseeably maybe they filed for bankruptcy in order to eliminate that debt. So we can see that the subsequent purchasers, the Lees, were BIOs. Chattel paper. What is chattel paper? Chattel paper are loans, can be bonds, and things of that nature. So, as I mentioned before, selling loans in the form of assignments is very common. Again, because retailers don't want to be in the business of running a bank, and so they discount their security interest loans to a creditor who is in the business of collecting over a period of time. And obviously they get the security interest at a discount from the seller. And that's how that whole business, works. So as our little slide shows, that when chattel paper or instruments in the ordinary course of business are purchased, Generally, these come free of any security interest. Now, having said that, let's talk about liens for a moment. What is a lien? It's a commercial law term. A lien is a security interest created by law rather than by agreement between the parties. So let's take, for example, an artisan's lien. This is a lien that is a security interest in personal property that attaches when a worker makes improvement to personal property. So let's take, for example, you bring your car into a gas station to be serviced, and they service it, and you come to pick it up, and of course they want to be paid. And you say, well, I'll pay you next week. But the gas station owner, the maintenance chief says, no, 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 it doesn't work that way. You have to pay for the service before we'll give you your car back. Well, this is a security interest lien that the artisan can make automatically, and that is withhold the car from the owner until they get paid. An artisan's lien, okay? Because the maintenance worker, the gas station, made an improvement to the personal property, to wit, the car. Now, let me distinguish this from another type of lien that we refer to as mechanic's liens. Mechanic's liens, of all things, refers to the result of work being done to real estate, such as landscaping, painting, electrical, plumbing, driveway paving, whatever. We would all agree those are improvements to real estate. Now, how does this work? Assume for the moment that we have a landscaper who comes and does all this landscaping to your property, and when it's time to get paid, he doesn't get paid. You don't pay him. Well, the landscaper can file a mechanic's lien against your property in the county recorder's office. It is a lien in the amount of whatever it is that you owe the landscaper. What's important about the lien? Well, if you try and sell the property, we have clouded title caused by the lien. And so the property cannot be transferred to a third party until the lien is paid for. Now, it doesn't matter who pays the lien, but the property can't be sold to another party until the lien gets paid. So that's how, if you will, liens attach when people don't pay for work that has been done to their property. Some of you probably are familiar with the landlord's lien, that if the tenant doesn't pay the landlord on time, then the landlord can take a lien in the personal property of the tenant. Now, that doesn't obviously involve animals or taking somebody's car. Now, the question, of course, comes up about priority of claims when you have multiple creditors. And so it's not unusual for a debtor to try and use the same collateral for one or more creditors. And so what are the rules when you have multiple creditors and priority of claims involving security interest? Well, the first general rule is a perfected security interest generally takes priority over a party with an imperfected interest. So clearly someone who's filed in the county recorder's office a security interest is going to take priority over someone, another creditor who has not filed. Now let's take the case where we have two or more creditors who have not filed their security interest in the county recorder's office. Then it's a first come, first serve. The secured party with the first interest to attach takes priority. When we have two or more creditors who have properly perfected their security interest in the county recorder's office, then the first to file takes priority. How about a secured party who has control or possession over collateral? If they have possession, or control of the collateral, then they will take priority over one who's only filed. So a purchase money security interest in inventory takes priority over perfected security interest if either of these things occur. Either before filing its PMI, the secured party checks for the earlier security interest, and if any are found, they've got a requirement to notify the holder of the new interest concerning the new PMSI. Good faith, right? Good faith. How about the secured party? Must then perfect the security interest before the debtor receives the inventory. Okay? Them's the rules. A non-inventory, so we're dealing with other types of property other than inventory, purchase money, security interest, and collateral in other than inventory takes priority over a conflicting security interest if the PMSI is perfected at the time the debtor receives the collateral or within 20 days after it. So you can see these rules are important, and if you deal in commercial paper, these are the rules that you need to become familiar with. So our Roser case, involves this fellow who's obtaining a loan from Sovereign Bank, which he used to purchase a car. But 19 days later, Sovereign Bank filed a lien on the car with the state of Colorado. Now, unknown to the bank, Roser had declared bankruptcy 12 days after he purchased the car. So the bankruptcy trustee argued it had priority over the bank because the bankruptcy filing preceded, that is, occurred before the bank's liens filing. The trial court agreed and held actually, I should say the bankruptcy trustee. Did Sovereign Bank, a PMSI holder, obtain priority over the bankruptcy trustee? What's our rule? If a person files a financing statement with respect to a purchase money security interest before within 20 days after the debtor receives delivery of the collateral, the security interest takes priority over the rights of the buyer, lessee, or lien creditor, which arises between the time the security interest attaches and the time of filing. So the bank satisfied the requirements of the UCC section. The filing of the lien constitutes the filing of a financing statement. So judgment was reversed for the bank. Ooh, dum da dum dum dum. Oh, foul, foul, foul. Default, default, default. We have a debtor who is not making their payments on time in accordance with their financing contract. Foul, foul, foul. That's not the way it's supposed to work. Ooh, what comes into play at this point? Well, we call this default. When the debtor defaults on their contract to the creditor. Bad, bad, bad. Because what are contracts? Promises, right? An exchange of promises. I promise to do this if you promise to do that. I promise to loan you this money to purchase this item, provided you promise to pay me monthly payments in this particular amount. But what happens when we have contract breach? Default. Well, this is where the secured party may lawfully take possession of the collateral. Specifically, they can repossess the collateral, whether it's a car, a boat, a trailer, a TV. Looking at it from the mortgage point of view with real estate, if you have default, the creditor, the bank, the whatever, can repossess, that is, foreclose on the real estate. Now, the creditor can, rather than take possession of the item, the car, the boat, the trailer, they may instead decide to sue the debtor for the money owed. Now, a secured party, how can they actually repossess the property? Can they, walk up to a debtor's home, knock on the door and hold a gun to his head to make him turn over the keys to the car or the trailer or whatever? Not exactly. There are two ways that a creditor, a secured party, can lawfully repossess their collateral. The first is by obtaining a court order requiring that the debtor turn over the collateral to the creditor. Or, as is sometimes the case, simply taking the collateral but not doing it that involves a breach of the peace, because clearly causing a breach of the peace, that is where somebody gets hurt or there's some injury incurred. Look, lives are more important. They are valued higher than property. So the Chapa versus Trakers and Associates case is a good example of what we're talking about. So we got poor Chapa she's defaulted on her car loan, so the Ford Motor Credit Corporation hired Trakers and Associates to repossess her white Ford Expedition. And that's commonly what creditors do. They hired repo people to go out and actually find the item and to seize it. So Tracer's agent observed Chapa's home waiting for an opportunity to seize the car, which is pretty normal. That's what they do. When a woman drove a white Ford Expedition out of the driveway and then stopped it, leaving the car running while she ran back into the house, the agent hooked up his tow truck to the car and escaped. Now, the car was the wrong one, though, belonging to Chapa's brother, who had an identical car. And two of their children were in the back seat already. When the agent stopped in a nearby street because, the Ford's wheels were turning, he discovered the children and returned them in the car to the now, as you would imagine, hysterical mother. So the non-debtor, Chapa's, sued Tracers and the Ford Motor Credit Company for breach of peace. And that's the question. The trial court originally dismissed the case, and they've appealed. And so the question is, did the agent commit a breach of peace when he repossessed the car? So the UCC says, look, conduct that incites or is likely to incite immediate public turbulence, or that leads to or is likely to lead to immediate loss of public order and tranquility, that's what we call disturbing the peace. Is that what happened here, do you think? So again, a part of the rule is if repossession is contested at actual time and in immediate vicinity of the attempted repossession, the secured party must desist. That is, stop. So that's why repo people usually sneak up and grab cars when they are, parked someplace, but they try and avoid front-to-front confrontation because that would violate the rule. Okay. Again, we don't want property causing, injuries, and so repo personnel know the rule, and that's why they usually sneak around when they do repossessions. So the question naturally comes, okay, what happens when the car, the trailer, whatever has been repossessed? What happens to it after we've had default and repossession? Well, as you would think, a secured party, the creditor, may sell, lease, or otherwise dispose of the collateral in any commercially reasonable manner. Now, banks, credit unions, or whatnot are not in the business of managing automobiles, the sale of automobiles, trailers, and things of that nature. And so they frequently, within 30 days, seek to sell, that is, unload the item for whatever cash they can get for it. But let's assume for the moment we have a $5,000 debt. The car or trailer is sold at a street auction for $4,000, leaving $1,000 yet unpaid by the debtor to the secured party. We call that a deficiency. a deficiency, that we have $1,000 that the debtor still owes the secured party. So the secured party can go back to court and request a deficiency judgment in the amount of the $1,000. And yes, the creditor, secured party, well, the secured party no longer has the car, but armed with that judgment, he can try and attach bank accounts and other assets of the debtor. Now, it is possible that normally there are negotiations before there is repossession by a secured party of a debtor's property, collateral. And so frequently they work out in accord and satisfaction. That is an agreement that, okay, I know there's a debt for $5,000. The car may only be worth $4,000, but look, I'll let you have the car if we can terminate the debt. And frequently creditors will do just that, to resolve the entire matter, conclude it by agreeing to take less than what the contract debt calls for, and that they turn over these security interest property to the creditor. But let's talk about redemption. So we have on Monday a repossession of a debtor's automobile because he's defaulted in his monthly payments. But the debtor has a lot of money. He's paid a lot of money over a period of time, and let's say he's only within a few months of paying off the debt. If he can come up with the rest of the money to pay off the debt, he may redeem the repossessed collateral. That is, he can pay off whatever is the remaining debt, along with whatever the default and repossession expenses were, and get his car back. That is the legal right of redemption. After collateral is sold, clearly there's nothing to redeem if that happens. Now, as hopefully some of you have experienced when you purchased high-ticket items, to include even mortgages, that, once a debt is paid, the secured party has a legal requirement. They have to return to you, usually the financing statements, and statements that indicate the debt has been paid off, okay? And so when you pay off the car loan, when you pay off your home mortgage, you will get in the mail your original instruments, and you're done with all future payments, and now you have evidence that you own the former collateral legally. Now, why is this important? Because assume for the moment your title has this lien statement on it. With the termination statement from the creditor, the secured party, you will go down to your DMV and get a new title made that has removed the lien statement on it. But you'll need the termination statement from the creditor indicating, hey, the debtor has paid off the debt. Them's the rules. That's how commercial transactions occur. So you can see these rules are helpful, and they facilitate commercial transactions between buyers and sellers, secured parties, and debtors. So hopefully this has been of help to you. I know you've had a lot to do with your first assessment test, and that's why I broke up the Secured Transactions Chapter 24 for you. You can find, not in the soft cover textbook, but in the online week 5 link, the entire chapter text for your reading and study before you take the quiz. Again, as always, I invite you to email me regarding any questions or difficulties that you're having. I'm here to help you work your way through. I'm your Sherpa, if you will, through commercial law and ethics. And anything I can do to help you, I'm here to do it. Have a good week. See you next week. Bye-bye.